In Nigeria, there is a saying that the courtroom is the last battlefield of the losing politician. In Rivers State, in 2025 and 2026, the courtroom became something else entirely. It became the first battlefield, the primary weapon, the opening move, not the last resort. More than 40 lawsuits were filed in the Rivers State crisis, not 40 allegations, 40 separate legal actions, in Port Harcourt, in Abuja, in the Court of Appeal, at the Supreme Court. Both sides, every institution, at the same time. And here is what almost nobody has explained clearly. As of today, in June 2026, the legal war for control of Rivers State, and therefore the legal war for who controls the 2027 ballot, is not over. The latest Court of Appeal judgment delivered in May 2026 has thrown the APC's entire internal structure in Rivers State into legal uncertainty. The party that was supposed to have won the political war may not be able to field candidates in 2027 at all, not because of an election, but because of a court. Stay with me, because this is where the story gets complicated and where it becomes important for every Nigerian who cares about what democracy actually means. Niger Brief is the channel that explains what is actually happening in Nigerian politics, not just what happened. Subscribe and let's get into it. Before we get to the current crisis, you need to understand something foundational. In the Rivers State War, the courtroom was never neutral territory. It was captured terrain, fought over, occupied and weaponized by both sides, and the accusations flew in both directions. On the weak side, the APC chairman in Rivers, Chief Tony Okocha, accused Governor Fubara of turning the Rivers State Judiciary into his exact words, a supermarket where the governor goes to buy judgments. He alleged that cases were being assigned to favorable judges at the governor's direction, and that every time an APC court proceeding produced an unfavorable result, the hand of Fubara's government was behind it. He even noted that whenever the National Judicial Council investigated judges, Rivers State always had a representative, framing it as evidence of systemic rot. On the Fubara side, the response was immediate. The governor's spokesman pointed out that Okocha's own APC had disobeyed a court order, a restraining order telling the party not to hold its internal congresses. The APC defied that order and conducted the congresses anyway. When the Rivers State High Court nullified those congresses for contempt of its own order, Okocha blamed Fubara. The Fubara camp's counter was blunt. You disobey a court order, and when the hammer falls, you blame the governor? He controls the executive arm, not the judiciary. Both sides were right about each other. That is the most uncomfortable truth in the Rivers State legal war. Both factions, Wike's and Fubara's, understood the judiciary as an arena to be won, not an institution to be respected. What differed was access, timing, and which judges were sitting when. And a retired panel of 3 senior jurists convened in March 2025 to review cases of public interest made this explicit. They found that the Supreme Court's February 2025 ruling had left, their words, a gap on the defection question. The court, they said, had made comments on defection without actually resolving it. The most consequential legal ruling in the crisis produced an answer to a question that was never the real question. Let us go to the heart of the legal dispute, because it has never been properly explained to a general audience. The entire Rivers State crisis rests on one unresolved constitutional question. Did the 27 Amekule lawmakers legally defect from the PDP to the APC in late 2023? If they did defect, Section 109 of the 1999 Constitution required them to lose their seats. Fubara's refusal to recognize them as lawmakers would have been constitutionally justified. If they did not legally defect, or if the defection was improper under the party structure at the time, then they were still valid assembly members, and everything Fubara did to exclude them was a constitutional violation. Here is the extraordinary thing. As of June 2026, no Nigerian court has delivered a definitive, appealable ruling on this question. The Supreme Court's February 2025 judgment sidestepped it entirely. The court ruled that Fubara had failed to prove defection because he had withdrawn his own legal processes before a court could rule on them. It did not say defection did not happen. It said it could not make that finding because Fubara had removed the evidence from the table. The defection question was supposed to go to a federal high court in Port Harcourt for a full hearing. What happened to that case? It sits in a crowded docket, overtaken by political events, emergency rule, defections, peace deals that made the original legal question almost irrelevant in practice, even as it remained theoretically unresolved. Here is what this means starkly. The ruling that suspended a governor, froze a state's federal allocation, and set in motion a 6-month emergency rests on a constitutional foundation that was never fully tested. Lawyers who have studied this case call it one of the most consequential examples of judicial gap-filling in Nigerian constitutional history. A court resolved a governance crisis without resolving the underlying legal dispute. The crisis moved on. The question remained. And then, in May 2026, the legal war came for Wike's side. Here is what happened. The APC in Rivers State has 2 men who both claim to be the legitimate state chairman. One is Tony Okocha, appointed through congresses conducted in late 2024. The other is Emeka Beke, recognized by a separate Rivers State High Court judgment as the authentic chairman. When the Okocha-led executive conducted those 2024 congresses, there was a court order in place, a restraining order telling the APC not to proceed. The APC went ahead anyway. A Rivers State High Court subsequently nullified the congresses for contempt of its order. The Okocha faction appealed, arguing the High Court had no jurisdiction. On the 29th of May 2026, the Court of Appeal in Port Harcourt delivered its judgment. It affirmed the High Court's jurisdiction and struck out the Okocha faction's appeal as incompetent. The implications cascaded immediately. The Beke-led APC leadership, the court-backed APC leadership, declared that every decision made by the Okocha executive between December 2024 and May 2026 was null and void. Every nomination, every communication, every political decision, including the APC screening exercise in May 2026 that cleared 28 Wike loyalists and blocked nearly every Fubara ally. All of it legally nullified.
Then came the warning that stopped political observers in their tracks. APC stakeholders in Rivers stated publicly that unless the party resolved this leadership dispute urgently, it might not be able to field candidates in the 2027 elections at all, just as the APC failed to field a governorship candidate in Rivers in 2019 because of unresolved internal legal disputes. The party that had apparently won the political war was now fighting for the legal right to exist in the 2027 ballot. This is the part the news summaries cut. Drop a comment. Did you know the APC's entire Rivers structure is currently under a court ruling? Tell me what you think this means for 2027. What does a party do when it has 2 chairmen, one backed by its own internal congresses and one backed by the courts? In Nigeria, you take it back to court, and you manage the chaos in between. The Beke-led executive, now court-affirmed, says it controls the party. The Okocha faction says the Court of Appeal's ruling was narrow and interlocutory, that the substantive case is still before the trial court and nothing is final. And the APC national leadership, watching from Abuja, is now expected to reconcile 2 party structures whose actions the courts have declared incompatible. Meanwhile, INEC sits and watches. The Electoral Commission cannot recognize a party's candidates until the party itself can demonstrate it has a valid, legally constituted leadership that produced those candidates through proper processes. If the Beke faction is the legitimate executive, then the primaries conducted under Okocha, including the assembly primaries, are under a legal cloud. If the Okocha faction ultimately prevails after full trial, then the Beke faction's decisions are equally questionable. There is also a third actor in this drama, the African Democratic Party, the ADC. This smaller party has been quietly positioning itself as a landing platform for political actors squeezed out of both the APC and the PDP in Rivers. Fubara's own allies have begun making enquiries. Toye Cole of the APC is reportedly unmoving about contesting the governorship on whatever ticket survives, and Kingsley Chinda, a PDP ally and House of Representatives member, has picked a PDP governorship form, hedging his bets across party lines. Rivers 2027 is not a settled race. It is a multiple vehicle pileup, with the courts deciding which vehicles are still roadworthy. Pull back from the legal details for a moment, because what we are describing has implications that extend far beyond Rivers. In Rivers 2027, the actual ballot, the moment a Rivers voter enters a polling booth and marks a paper, may be the least consequential part of the electoral process. The candidates who appear on that ballot will have been determined by courts. The parties they stand under will have been validated by courts. The primaries that produce them will have been adjudicated by courts, and the assembly that certifies the results will have been constituted by a Supreme Court order. Every filter between the voter and the outcome is now a legal proceeding. This is not unique to Rivers. It is the direction Nigerian electoral politics has been moving for 20 years, away from the ballot box as the decisive moment and toward the courtroom as the arena where power is actually allocated. What Rivers State has done is accelerate that trend to a speed where it is now visible to the naked eye.
The legal framework has not failed. The legal framework is being used exactly as political actors intend, as a parallel system of power allocation that produces legitimacy without requiring public consent. For reform-minded Nigerians, for those who believe that a vote should mean something, this is the challenge. It is not enough to demand free and fair elections. You must demand a judicial culture that refuses to be the instrument of political ambition. You must demand a bar association that calls out judge shopping publicly, regardless of which party benefits. You must demand INEC guidelines that protect the ballot from being predetermined by the courthouse. None of that is simple. All of it is necessary. Let me tell you what the legal war for 2027 in Rivers State has produced so far. It has produced a Supreme Court ruling that left its central question unanswered. A state of emergency applied to a governance dispute. An APC party structure nullified by its own contempt of a court order. A screening exercise declared void by the winning faction. A sitting governor driven from the 2027 race not by voters but by legal and political attrition. And a 2027 election that right now no one can predict, not because the voters are unpredictable, but because the legal structure is. The lawyers are still filing, the courts are still sitting, the factions are still maneuvering. And the 8 million people of Rivers State are watching and waiting to find out if their vote in 2027 will mean anything at all. That is the real verdict this legal war needs to deliver. Not who controls the APC, not who chairs the party, not which faction gets the Supreme Court's blessing this time, whether democracy in Rivers State and by extension in Nigeria still belongs to the people. If this gave you clarity, share it with one person who is trying to make sense of Rivers State politics. Like, subscribe, and I will see you in the next.